Okay, I saw Heiko had his microphone on, but I didn't actually hear him speaking. Let me just check something.
Can you hear me now?
Okay, I've changed my settings. Heiko, if you can just talk again, please.
Good evening. Can you hear me?
I can hear you. Thank you so much, Heiko. Okay, great. Everything is sorted. I'm recording the class. Let me just share my screen. And while I'm sharing my screen, we have 2 more formal lectures left tonight. Exactly when I will have an examination preparation class where I will go take you through the layout of the exam, give you some tips for the exam, etc., etc., etc. There you are. Just confirm that you can see that. It's the document that I've been using all along. Once we've finished all the lectures, I will tidy it up and also share that with you, if it could be of assistance for the purpose of your exam preparation. Okay, so we are busy with partnerships. Last week on Wednesday, we did the rights and duties of partnerships. And then specifically, when it came to the management of the partnership, where it's discussed in Unit 13, I mentioned to you that I'm that because it's pretty much repeated. Unit 14, namely contractual liability of a partnership. Now, you will understand, because you are all grown-up people that are already employed, already have some business experience, some real-life savvy, you'll understand how incredibly important the issue of contractual liability of a partnership is. It is essential to partnerships that the intention of the partnership must be to make a profit. There must be a joint business with the intention of profit. And you cannot do business if you do not enter into contracts with third parties. It's as straightforward as that. Now, Unit 14 deals with the question of is a partnership bound to a contract entered into by one of the partners. That's essentially the issue that we address in this unit. Is a partnership bound to a contract entered into by one of the partners? But we can rephrase this, because you'll also remember everything I told you about the fact that a partnership is not a juristic person, that the partners are personally liable, that once the partnership dissolves, they become joint and several liability. You hopefully understand the concept of joint and several liability by now. So we can rephrase that and change it to, is a partnership, not a partnership, because a partnership isn't an entity, is a partnership, are the partners bound to a contract entered into by one of them? Let's say, just an example here, we've got Rushay, Haiku, and Sophia as our three partners in a partnership business. Rushay enters into a contract on behalf of the partnership, but eventually things don't work out. The business goes pear-shaped. They decide to agree to dissolve the partnership, but creditor Lachia still wants her money. Now, the crucial question here is, are Rushay, Haiku, and Sophia jointly and severally liable for the payment of this contract entered into by Rushay? To take it to extremes, can Lachia collect her money from Haiku? As you can see, that can have far-reaching consequences for the partners, because if the correct requirements have been met, Lachia will be able to claim the money that is owed to her from Haiku, even though it was Rushay that entered into the contract. So that is what we're looking at this unit. I said, if the correct requirements have been met. So we're going to be looking at these requirements. Now, the first thing is that it is a natural legal consequence of a partnership that all partners have the right to participate in the management of the partnership. If we go back to the rights and duties of partners, we saw one of the rights and duties is the duty to carry on the business of the partnership, to commence and carry on business as agreed. Hand in hand with this one is the fact that partners have the right to participate in the management of the business. However, this is a natural legal consequence. It follows because it is a partnership, and accordingly, this can be changed. In a partnership agreement. So, although it's a natural legal consequence that all partners have the right to participate in the management of the business, partners can agree amongst them to change this. So, when they entered into the partnership, Rushay, Haiku, and Sophia can agree between them that Sophia will be the managing partner and that Sophia is the only partner that has the right to enter into contracts on behalf of the business. Or they can agree that all three of them have the right to contract, but for contracts above a certain amount, say $1 million or whatever, written consent of everybody is required. They can put whatever they want to in their partnership agreement. If there's no agreement to the effect, everybody has equal rights. So that is the first point that you need to understand. All partners have the right to participate, but this can be changed. Now back to our question. When will a partnership be bound to a contract? We have three requirements there, namely, why is this giving me a 5 and not a 1? Contract must be valid, must be entered into on behalf of the partnership. And then the third one is the representative. So this is the partner who's actually contracting. Must be authorized, or don't worry about that right now. I'm going to elaborate on all three of these. So the first one is straightforward. The contract must be valid. The contract between the partnership and the third party must be valid. 5 requirements for a valid contract. You know those by now. A partnership cannot legally enter into a contract to buy unlicensed firearms, because buying and selling unlicensed firearms is illegal, which means the contract is not valid and the partnership will not be bound. It must be entered into on behalf of the partnership. The representative, the partner entering into this contract, must make it clear to the third party that they are not contracting personally, but they are contracting on behalf of the partnership, in the name of the partnership. That information, whether this was happened or not, whether they profess to enter into the name, in the contract in the name of the partnership, I will provide you with that information in the case study. Always remember with case studies not to make up your own facts. I write the sub stories. You just give me the answers. So those two requirements are straightforward and don't actually require much elaboration. On behalf of the partnership or in the name of the partnership, it must be valid. You don't need to give me a discussion of the 5 requirements of a valid contract, but do remember when you are doing a case study about contractual liability of a partnership, just give me a second, please. Hello? Yes. Yeah, okay. I'm just busy teaching at the moment. Yeah, I will bring a chair. I don't know, where's my chair that I left there yesterday? It's fine. I will tell him to just wait there. I am teaching at the moment. As soon as I've finished my class, which will be in about half an hour, I will bring him a chair and a blanket. Everything. Okay. Okay, sorry about that. Just a personal issue that I had to deal with. Okay, so remember to mention those comments, those requirements, that the contract must be valid, it must be entered into on behalf of the partnership. The main requirement that could be problematic is the issue of authority. With regard to authority, I need to take you back to Unit 11, where we did agency. You get your different types of authority. First of all, is there express authority? Did Rushay, Haiku, and Sophia agree on this contract and instruct Sophia to enter into this contract? If there's express authority, obviously the partnership is bound. What if, however, this contract was just part of the business and there was no express authority? Is there implied authority? And in light of what I said earlier, that all partners have the right to participate in the management of the business. All partners have implied authority. All partners have implied authority to represent to represent the business, to represent the partnership. So obviously, if there's implied authority, the partnership will be bound. If there's implied authority, the partnership will be bound. But as you've seen earlier, this concept that all partners have the right to participate in the management of the business can be changed. So the implied authority can be changed. If our partners, Rushay, Haiku, and Sophia, have agreed that Sophia is the only partner that has the right to enter into contracts with third parties, then as a necessary consequence, Rushay and Haiku do not have implied authority. Their implied authority has been taken away from them. If you had something and somebody took it away, you don't have it anymore. It's important that you understand this, because I find that students battle with this concept. They battle with the concept of There was a partnership agreement which made different arrangements with regard to authority, and now certain partners no longer have implied authority. If the partners agreed that only Sophia may enter into a contract on behalf of the partnership, that means that Rushay and Haiku do not have implied authority. It has been taken away from them. And now you will recall when we did law of agency that if there is no authority, if the principal did not give authority to the agent, to the representative, the principal is not bound. Do you remember that? With regard to partnership, however, the common law of the law of agency works a little bit different. That principle that I taught you then still stands. If Haiku did not give Rushay authority, Haiku is not bound. But now we are talking about a partnership. So what is the case if the contract is unauthorized? If there is no express or implied authority? That brings us to what I said there, that the representative must be authorized or it must be in the scope of the business. Because the law of partnership recognizes something called the mutual mandate. Concept of the mutual mandate means that the partnership, i.e., all the partners, will be bound to a contract entered into on behalf of the partnership if it is in the scope of the business. Even if there was no implied authority. So Rushay, Haiku, and Sophia have agreed that only Sophia may represent the partnership, may enter into contracts with third parties. Haiku goes and enters into a contract that is in the scope of the business. It is a partnership that runs a shoe shop and he buys a consignment of shoes. It's in the scope of the business. Even though he did not have implied authority, the partnership will be bound. It's as simple as that. That is how partnership works. So even if he didn't have implied authority, partnership will be bound. So upon dissolution, all three of you will become jointly and severally liable. And creditor Rauna can collect her outstanding debt from Rushay. Even though in terms of the partnership agreement, Haiku was not allowed to do this, Rushay can still potentially become bound and liable. Far-reaching consequences. Choose your partners carefully. There are also other manners in which a partnership can become bound to a contract. This takes us straight back to Unit 11. Here, the principles are applied exactly in the same manner as I told you in Unit 11. Certain instances where it's not in the scope of the business. If it's in the scope of the business, you don't need to make use of apparent authority, because then the partnership is bound, full stop. As simple as that. If it's not in the scope of the business, obviously the mutual mandate will not apply, but concept of apparent authority created the impression that the representative was authorized if the partnership created the impression that the representative was authorized, they will become bound So that is the same as apparent authority that we did in Unit 11. If you're feeling a bit confused about that, go back to Unit 11. It is set out quite clearly in Unit 11. And then also the concept of ratification. Why can't I type? Ratification, I'm not going to elaborate on this. Also the same as Unit 11. If Haiku bought a racehorse, he didn't have authority, he bought a racehorse. It's not in the scope of a shoe shop, but the other partners agree that, wow, owning a racehorse seems like a cool idea. They can ratify the contract. So apparent authority and ratification is exactly the same concept as I taught you in Unit 11. So go back and revise that. So that is Unit 13. It is in the exam. It is one of the questions concerns Unit 13. Unit 14, contractual liability of a partnership. I always have that in my exams. So go over those notes and make sure you understand them. Any questions? Okay, Daniel is fine. Everybody else fine? Okay, great. Wonderful. It wasn't a long class, but it is an important class, important part of the work. Please make sure that you understand this. Go over through the unit. And if there are any queries, please ask me Wednesday evening before we start with the last unit. Thank you very much for attending. Bye.
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 Bye, ma'am.